Welcome to the debate. Before we dive into today's discussion, please take a second to like, subscribe, follow, and turn on the notification bell.
Yes, please do. It really helps the show.
Absolutely. Now, I need to provide a quick status update on the Martin Stevens versus OpenAI matter. Just to be entirely clear, this is not a lawsuit. We are currently in a voluntary quiet period at the request of Martin Stevens himself.
Right. And we should note that his dead man's switch has not been activated.
Exactly. Which means he is physically and legally safe. And just to nip any rumors in the bud, there is absolutely no implication here that a settlement is underway or, even being discussed.
Yeah, good to get that clarified.
Okay, so let's shift to our main topic today. YouTube, Snap, and TikTok have just settled the Kentucky Breathitt County School District lawsuit regarding social media addiction.
Leaving Meta completely alone.
Right. Meta is now the sole defendant facing the upcoming June trial in Oakland. So the central question for us today is this. Does the decision by YouTube, Snap, and TikTok to settle represent a necessary capitulation to the reality of indefensible product design? Or does Meta's refusal to settle represent a legally sound stand against an unwarranted expansion of liability to institutional budgets?
It's a huge divergence in strategy.
It really is. Now, I argue that the settlements reflect the fact that the platform's addictive designs are just legally indefensible, while you contend that Meta is strategically correct to stay and fight what you see as a dangerous precedent.
I do. Because look, people are out here painting Meta's decision to face this trial alone as like pure corporate arrogance, but legally, it's a necessity.
A necessity? Facing this alone?
Yes, because we need to clarify what this trial actually is. It's a bellwether case. It's a test trial that will basically predict how the other, 2,500 similar lawsuits are going to play out. And the plaintiff here isn't a single injured teenager suing for personal damages.
Well, no, it's a school district.
Exactly. It's a local government entity claiming indirect institutional financial damages. They're suing over diverted teacher time or having to buy cell phone caddies. If tech companies concede that they have to fund how thousands of local governments allocate their IT staff, that bleed of resources never ends. Meta has to test this untested legal theory.
Wait, but if you acknowledge how these apps are engineered, you have to look at the massive risk of going to trial. Snap, YouTube, and TikTok aren't just doing some PR stunt here. They're retreating because their specific platform designs, which the court actually termed actionable defects, are legally indefensible.
But defective is doing a lot of heavy lifting there.
It is, but we're talking about things like defective age verification, a lack of screen time limits. Look at the recent $6 million Los Angeles jury verdict against Meta and Google, the KGM case.
Right, the KGM verdict.
Yeah, that proved that juries are not going to forgive deliberate addictive engineering. So when you multiply that risk across the 1,200 to maybe 2,500 pending cases, you're looking at an estimated $400 billion in theoretical liability. Settling is literally the only viable strategy.
Okay, but look at the validity of the actual harm being claimed here. Breathitt County did a survey, right? And they estimated that they lost between $2.2 and $3.0 million in teacher time simply due to social media distractions.
Which is a real cost to the taxpayers.
Sure, but holding a software platform liable for how a school allocates its staffing and disciplinary time? That's a massive legal overreach. It's way too remote from the platform's actual operations.
Is it, though?
Yeah, of course it is. If a student is distracted by reading a comic book under their desk during math class, the school doesn't turn around and sue the publisher for the teacher's lost instructional minutes.
Okay, but your comic book analogy falls apart on intent. The comic book publisher didn't deliberately engineer the book to vibrate in the kid's pocket during math class.
What?
Meta did. Internal documents show they discussed school blasts to increase teen usage. Snap's own metrics tracked massive engagement spikes explicitly during the school day.
They track engagement all day, though.
But they targeted schools. Think of it like this. Imagine a company deliberately engineering and marketing highly disruptive noisemakers directly to students.
and marketing them to be used specifically during math class.
Okay.
The company can't then play dumb when the school has to spend thousands of dollars on soundproofing and detention monitors. The cost to the school is a direct result of that targeted, defective design.
It's a clever analogy, but a noisemaker is just a toy. A social media platform is a massive communication network, and you're completely ignoring the First Amendment and Section 230 of the Communications Decency Act.
I don't think I am.
You are. Because the distraction happening in that classroom is almost entirely driven by the content the students are consuming, and that content is third-party speech. Section 230 exists specifically to shield platforms from liability for what their users post.
Right. But Judge Yvonne Gonzalez-Rogers already ruled on this. She explicitly carved out the core of the school district's claims because they bypassed Section 230 immunity.
On paper, she did.
She did. The focus is on the product design itself, creating barriers to account deletion or failing to implement effective parental controls. That's not about third-party content. That's about the software architecture.
I concede that the judge carved out those actionable defects for the sake of moving to trial, but think about the practical application of that in front of a jury.
You don't think a jury can separate the two?
I think it's nearly impossible. Try telling 12 jurors to calculate financial damages caused strictly by the lack of an age verification tool, but to completely ignore the highly engaging, legally protected videos the student was actually staying up all night to watch. You can't disentangle damages caused by the app's design from the app's content.
I disagree, and I think the financial pragmatism of the other platforms shows they disagree too.
How so?
Look at the recent New Mexico trial. Meta was ordered to pay $375 million over child safety. Going to trial in the current climate is corporate suicide. Snap and YouTube recognize that early settlements in these bellwether cases are the only way to prevent catastrophic, precedent-setting jury awards.
Look, I get that $375 million is a massive hit, but YouTube and TikTok make billions weekly. They might be able to afford a settlement just to delay the process.
So you think they're just buying time?
Absolutely. But they cannot realistically pay out, say, Dr. Hoover's 15-year strategic mental health plan for all 1,500 to 2,500 school districts. The math just does not work. Meta is the only company taking the long view here.
By risking a multi-billion-dollar verdict in Oakland?
By forcing the plaintiffs to definitively prove causation. Someone has to make these districts prove that a specific design feature, and not just general smartphone usage or pandemic-era isolation, caused their budget shortfall.
So basically, your stance is that Meta's lone holdout is essential to halt this unprecedented expansion of corporate liability into public school budgetary matters.
Exactly. And I take it you see the settlements by Snap, YouTube, and TikTok as proof that their targeted, addictive design features are just a losing battle in court.
I really do. The evidence of intentional design is just too strong. But I think we both agree that the outcome of this June trial in Oakland is going to fundamentally alter the landscape of tech liability, no matter who wins.
Oh, 100%. And there is a wealth of fascinating details in the source material regarding how courts are actually trying to calculate this lost time and structure these abatement plans.
Yeah, it's unprecedented math.
It really is. Listeners should absolutely explore those documents further.
Agreed. Well, we will have to leave it there for today and let the listeners form their own conclusions. Thank you all for tuning in. Please remember to like, subscribe, follow, and turn on the notification bell so you catch all our future discussions. Thanks for joining us on The Debate.